5 seconds to go. Start. The supervisory jurisdiction of the magistrate suddenly ceases midway through the pre-trial proceedings would amount to a travesty of justice, as certain cases may cry out for further investigation so that an innocent person is not wrongly arraigned as an accused, or that a prima facie guilty person is not so left out. There is no warrant for such a narrow and restrictive view of the powers of the magistrate, particularly when such powers are traceable to section 156.3, read with section 156.1, section 2H, and section 173.8 CRPC, as has been noticed herein above, and would be available at all stages of the progress of a criminal case before the trial actually commences. It would also be in the interest of justice that this power be exercised suo motu by the magistrate himself, depending on the facts of each case. Whether further investigation should or should not be ordered is within the direction of the learned magistrate, who will exercise such discretion on the facts of each case and in accordance with law. If, for example, fresh facts come to light which would lead to inculpating or exculpating certain persons, arriving at the truth and doing substantial justice in a criminal case are more important than avoiding further delay being caused in concluding the criminal proceeding. Now, so far as the reliance placed upon the decision of this court in the case of Rama Chaudhary Supra relied upon on behalf of the respondent accused is concerned, it is required to be noted that in the said decision, this court was considering the scope of sections 173.8 and 173.82 CRPC and the right of the police to further investigation. It is observed that the police has no right for fresh investigation or re-investigation. However, this court had no occasion to consider the powers of the constitutional courts which are dealt with and considered in the case of Bharti Tamang Supra and Dharampal Supra. Applying the law laid down by this court in the case of Dharampal Supra and Bharti Tamang Supra, and to do the complete justice and in furtherance of fair investigation and fair trial, the constitutional courts may order further investigation, re-investigation, de novo investigation, even after the charge sheet is filed and the charges are framed. If the submission on behalf of the accused, and even as observed by the High Court, that once the charge sheet is filed and the charges are framed, there may not be any order for further investigation, re-investigation, de novo investigation is accepted. In that case, the accused may see to it that the charges are framed to avoid any fair investigation, fair trial. It would lead to travesty of justice. Applying the law laid down by this court in the aforesaid decisions and the principle of law laid down herein above, it is required to be considered whether a case is made out for further investigation, fresh investigation, re investigation, de novo investigation, or not. It is required to be noted that in the present case, the allegations in the FIR right from very beginning were against the accused number 13, who at the relevant time was the sitting cabinet minister occupying the high position. Even at the relevant time, when the state police investigated the FIR bearing number 120 of 2020 in the first charge sheet, and the second charge sheet did not name the accused number 13. Even the investigation was also conducted in a perfunctory manner. The real investigation started only after the intervention of the High Court and after passing various orders in the present proceedings by the High Court. Stop.